I request the speakers to kindly come on stage. Thank you.
Good afternoon, everyone. I hope everyone had a nice lunch. We will try not to put you to sleep. I expect a very lively debate amongst our panelists. But before we start, it would be remiss of me not to say a huge thank you to the MCIA for their untiring efforts to put on this conference year on year. The conference really brings together arbitration practitioners from all over the world to my home country. And in the global economy, it is really an understatement to say that India is a key player. Tariffs, sanctions, all of that notwithstanding, cross-border trade continues to flourish, and domestic growth really is reaching a peak. And that growth spans industries. It is sector agnostic across both traditional and non-traditional sectors. So here with me today are three general counsels representing India's growth story across these varied sectors. Starting from the far end, we have Mr. Vikash Jain, who's the Group President and Global General Counsel of Renew Inc., which is one of India's leading renewable energy companies. Right next to him is Ms. Medha Srivastava. She's General Counsel at Hashed Ventures. It's a South Korea headquartered venture capital fund investing in blockchain and emerging tech. And right next to me is Kanishk, a dear friend. He is the head of Uber's legal affairs in India and South Asia. As they, the GCs, are really the end users of arbitration and ADR, it is really my privilege to hear from them their insights about their experiences with arbitration. With thanks to each of you, thank you so much for coming and sharing your valuable time with us. I'd like each of you to tell us and the audience a little bit about your experience with arbitration. So perhaps if I can start with Vikash. Sir, over to you.
Thank you and good afternoon to one and all. My name is Vikash Jain, and as Sharmishta said, I am the Global GC for Renew Energy Global PLC. It's a NASDAQ listed organization with major operations in India. It's the largest IPP in the renewable sector in India. In my previous versions, I have worked for multiple organizations across multiple roles. My experience in arbitration stems from the various matters that I've handled for my employers, and some of them against the sovereign as well. Commercial arbitrations, global arbitrations, cross jurisdiction arbitrations. So, really speaking, the nuances of each one of them are very different. There are multiple factors at play, and we can talk about those experiences as we detail it out in the next few minutes, if I may call it. But we'll get to interact, and I would request all of you to participate in it. It would be a good interactive session. Thank you.
Thank you. Good afternoon, everyone. I'm Medha Srivastava. I'm General Counsel for Hashed. We are a South Korea headquartered venture capital fund, one of Asia's largest in the blockchain and emerging tech space. My interaction with arbitration in this role, at least, has been varied and spans jurisdictions, so that's something that we can speak about. So far, it has not actually happened in India, and we can also talk about whether that's a good thing or not. but yeah, so a lot of it is, it's interesting to see how different jurisdictions deal with arbitration, what is the kind of forums that they prefer to use. Given that we invest globally, we see a lot of differences between when we invest in the US as opposed to when we are investing in APAC. So that's some very jurisdiction-specific differences. And of course, because we work in the blockchain Web3 industry, which is really fast-moving, new age, there are a lot of other considerations at play which assume a lot of significance when we want to get into either arbitration or when we want to settle a potential dispute. So happy to speak about it and look forward to an engaging discussion here.
Thanks, Medha. Kanishk.
Thanks, Sharmishta, and thank you for having me on the panel. I am Kanishk. I lead the legal team for Uber in India and a few other countries in the region. I would love to say that I know nothing about disputes or arbitrations or litigations, but unfortunately, that's not the case. We have had a fair share, and in my previous role, in my previous life, I was also on the other side of the table was when I was in private practice. Again, there also we have seen a lot of disputes and have supported clients there. But in the current role, of course, there are a lot of regulatory litigations, there are a lot of other challenges, but most of our contracts, whether with local counterparties or global counterparties, do end up having arbitration clauses, right? And unfortunately, some of those do from time to time go into dispute, and that's where we get exposed to arbitrations, whether seated in India, SIAC arbitrations, or LCIA or elsewhere. So we have had our fair share of challenges and issues, and that gives us a unique insight and somewhat slightly different take on how arbitrations have been working or not working in some parts of the world, and how they can be improved.
Well, thank you. What's unfortunate for Kanishk is fortunate for me. I like hearing a GC saying sometimes these arbitration clauses bring about disputes, because that's really where we come in, my role comes in. But that said, even before we get to a dispute, let's start at the very beginning. When you are negotiating as general counsel an agreement, you have a choice in front of you. You don't necessarily have to go for arbitration. You could go for litigation in your domestic courts or another court. And what I'd like to hear from you is the thought process that goes behind the decision to choose arbitration over litigation. Perhaps Vikash, you may want to comment on this.
Sure. Thank you. So it's a very fundamental question, and I'm sure many of you sitting here would have faced it and overcome that. To me, the single biggest question when it comes to whether to have a arbitration clause in the agreement or not is fundamentally, I would say, centered around first the issue whether the parties are locals, and is it India based or can it be based overseas. If it is a contract between domestic parties and we really do not have any, I would say, practical answers around having it outside India, then the fundamental question is a choice between a civil court and an arbitration. And as most of you would know, civil courts in India take forever. I would, with all due respect to the judiciary, it's like not in my lifetime kind of a situation. And that, for all effective purposes, leaves us with very little choice but to go for arbitrations. The commercial courts have started stepping in and coming into fray, but we really need to see how effective they are so far.
Thank you. That's very helpful. Kanishk, would you like to?
So I would
weigh in?
echo everything that Vikash has said. I think that's the fundamental choice that you have, and probably teaching to the choir, everyone's aware of the challenges that a lot of municipal courts have, right? So, and especially if you look at it from a perspective of a player who has global footprint and is not wedded to any local jurisdiction or courts, it is an obvious choice, right? Because very often, if not always, you are dealing with counterparties from various different jurisdictions. Obviously, selecting local courts does not appear to be neutral, and on top of all the challenges that courts bring about, to say that, oh, you might be a party from some other country, but you have to select my local courts is always a challenging conversation. And that's where arbitration becomes a natural choice on top of all the other benefits, whether it's speed, efficiency, sometimes even cost, right? Because with speed and clear timelines come in cost. in our traditional court systems, even though going in costs may be relatively low, but if it stretches over a long period of time, all the cost benefit analysis would tell you that it's arbitration that one should be going for.
Yeah, on costs, I'll put a plug in there. Costs for going to court, the court fees might be lower, but senior counsel costs, as everyone in this room is aware, are very high and much higher than foreign firm fees. So with that plug in there, Medha, would you like to comment on this question as well?
Yeah. So, I do not have similar challenges as my co-panelists in terms of wanting to go to courts in India per se till now. But speaking from a perspective of a company which has its global footprint, given the number of jurisdictions we invest in, I think arbitration is obviously the choice of dispute resolution. As an investor which is coming in from outside, it provides a lot more structure and familiarity to us than courts would. And specifically from the point of view of the kind of industry that we operate in, I think it is important that the persons who are adjudicating your matter are somewhat familiar with the way the technology operates to be able to provide a judgment which might work for at least one party, right? So, and not to say that courts will not have that, and judges do familiarize themselves across jurisdiction globally, but obviously arbitration provides a much easier route to us to be able to deal with disputes then.
Well, thank you. All right, so now we're at this other fork in the road. You've decided that you want to have an arbitration clause in your agreements. But the decision point now that has to be made is, do you want to go for institutional arbitration or would you like ad hoc arbitration? And in India, I know there are many ad hoc arbitrations that take place, much more so than in the jurisdictions where I practice. But I'd like to hear from you, perhaps, Kanishk, you'd like to go first. What's your preference, institutional or ad hoc?
So I think that's a great question, and even though a lot of folks might believe that institutional arbitration is the way to go, I think that's a decision that one has to take every time you're drafting an agreement. And there are a number of nuances to it, but I think the biggest one is, are you going for familiarity? Are you going for certainty, for a rule-bound decision-making? Or are you looking at other considerations like cost, like where you want to seat it, etc.? So 9 times out of 10, when you're drafting developed contracts, and generally you would know that these are extremely developed, complicated contracts. We are not talking about simple trade contracts which used to be common in the previous century. You would obviously go for ad hoc arbitration just because of familiarity, certainty, and a more rule-bound nature of the framework, as opposed to ad hoc, where, of course, local courts may at times have a role to play. The rules of the game may not be as certain as an institution might offer you. So these are the two choices. But to be honest, ad hoc does come into play sometimes when you are looking at contracts which may not be extremely high-value contracts. You want to restrict yourself within a certain geography. You want to take the benefit of local courts, and you want to have that ability to go to them, whether it's for appointment of arbitrator or for at any other stage of the arbitration. Ad hoc also makes sense sometimes because, unfortunately, very often institutional arbitrations come with a price tag which is higher than some ad hoc arbitrations.
I'd like to add one thing over there that you mentioned, Kanishk, is about costs and value of disputes. And sometimes, I've heard this many times in my practice, that if it's a lower value, let's go for ad hoc. The one thing to keep in mind, and it's worth looking at every institution's rules, is rules will have provisions which will say that if the value of the claim is underneath a certain amount, let's say it's less than $1 million, then you can actually have a much more efficient arbitration process within the arbitration framework. And you also have the benefit of the framework of the institutional rules, the costs in that case as well. are much lower than the costs of, let's say, what a $1 billion arbitration would entail. So just worth keeping in mind that even within the institutional framework, there is the space for low-value disputes to be heard and done at a much more efficient and economical way than what you would expect, let's say, a $100 million arbitration.
And that's great. But I honestly feel I don't think we have explored that enough, and that needs to be explored more by everyone, by of course corporations like ours, but even other disputes can probably eventually find their way into the institutional framework, and this could be a good way to get that in.
Just add,
Vikash, go ahead.
add an element to that same question. As a matter of, I would say, more practice for lower value claims. And first of all, I agree with what Kanishk said earlier, that there is no cookie cutter approach for whether it's a large value or a small value. But generally, where the contracts are less likely to be significant from an overall perspective, there is a growing trend of moving from ad hoc towards institutional. And I would say, when I say institutional, I mean domestic institutional more. Because again, domestic institutions offer a better value proposition. Taking a step back, we talked about the cost element. I wanted to bring one more dimension to it, which, at least in my experience to the legal fraternity, doesn't come out very evidently. It's the question of speed. We look at speed only from a dimension of time. It's not actually only time. In most of the high value claims, especially in the Indian jurisdiction, where cost and carrying values are typically not allowed, there the time value of money, the interest cost so called, becomes a big variable. And that's a big cost. I can give examples of that, but I assume most of you understand that. So if a arbitration process is likely to take, say, 2 years versus a litigation which is likely to take 5 years, even if the probability of a risk in the arbitration is slightly higher, my preference would be to go towards arbitration than towards the litigation, for the simple reason that the probability of realizing value 3 years earlier becomes higher, and hence the earlier the NPV or the net present value of that litigation or that dispute to me is higher.
Very interesting. Medha.
So, I mean, we've had some experience with ad hoc arbitration clauses, and they've not been the best. So, I think apart from that, I feel that in the blockchain industry specifically, and I'm speaking from the perspective of where I'm currently working. The company may be incorporated somewhere. Your founders would be located somewhere. We come in as an investor from somewhere else, and therefore, institutional arbitration makes a lot of sense for us in terms of governing set of rules that are there, the procedure that is there. We can decide we are very clear about what procedural law will govern the arbitration. There is a little more conviction of the enforcement of the arbitral awards at the end of it. And as an investor in this industry, I feel that we would anyways prefer not to litigate with any of our portfolio companies, right? But if it really comes to that, I have seen that most portfolio companies also prefer to go for institutional arbitration. When they're fundraising from VCs, when they are in the US, they have a certain set of institutions that they go for. Singapore, Hong Kong, again, go for a certain set of, like SIAC, Hong Kong International Arbitration Center, very popular institutions. In US, American Arbitration Association.
One thing that each of you have touched upon briefly, and this is really a topic that we can spend an hour debating on, is the seat. Now, the seat brings with it the supervisory jurisdiction of the courts at the seat. So perhaps staying with you, Vikash, could you tell me a little bit more about the seats that you choose? And also, I'll make it a compound question, your experience when litigating against the sovereign?
So, as I said earlier, this choice of seat is more driven, I would say, by the prejudgment around the enforceability. That's the single biggest driver. And the speed of it, of course, which is a key determinant. The more the chances of the opposite party being able to influence the system, the lower are the chances of choosing that system. I am sure all of you understand that. Having said that, the aspect around it is going overseas is a costly affair from a seat perspective. It's a balance, it's a fine balance between cost and results and enforceability. Results here effectively mean enforceability. The question really is, it's more about the facts of the case and more about the context of the case, how you anticipate, is there a likelihood of the dispute coming in? What is the size of the dispute that would come in? How would the costs operate? What is the availability of the subject matter experts in that area, in that jurisdiction, or in that framework? So all those play a big role. Talking about my experience in the, I would say, an arbitration against the sovereign or sovereign institutions, indirect sovereign institutions. I have had several such cases. There, the choice is very simple. As I mentioned it earlier, it's binary choice. We simply move abroad for obvious reasons. Ad hoc and institutions, when we move abroad, our general preference is to go towards a reputed institutional organization. And again, there's no cookie cutter here. Having said that, then it's a question of how do we enforce it? And ultimately, when it comes to India, in some form or the other, it's all about the efficacy of that remedy. I hope I answered the question.
Oh, yes, very much so. Go ahead, Medha.
I agree with everything Vikash said. I think in terms of the pre-arbitration decision making, even when we enter into an agreement, which institution we'll select depends a lot on who's your counterparty. I mean, unlike him, we don't deal with the sovereign. We do a lot of private contracts, right? So who's the counterparty? Where are they based? What is the nature of our contract? Is usually it's all like investment agreements. So what am I hoping to achieve out of it? We've seen in the last few years actually SEAC come up in a big way in trying to also have a panel of arbitrators who are very tech focused, very familiar with the sector that we work in. Similar experience we've noticed with JAMS in USA, also American Arbitration Association. Even London has a good tech panel of tech arbitrators. So depending on the company that we are investing in, the kind of the value of the investment, then we go accordingly. We try and select arbitration panels. It's not that we would not select Singapore if the company is in Singapore, just because they seem to maybe more familiar. But we would still select SEAC because we feel that we have that kind of faith in the institution itself to provide the efficient arbitration process. So I think that when we go for which arbitration institution to select, a lot of it depends not just on the counterparties, but also the familiarity of that institution with the sector that we operate in, the efficiency cost-wise, obviously. I do not want to make a $2 million investment and then spend $2 million on counsel fees in arbitrating. So, or for arbitration fees. So all of that cost obviously makes a difference, but I feel sector familiarity is is one area that we give a lot of focus to when we go for selecting the institution.
And if I could just add a couple of things to that. See, for us, the biggest factor is the local court system, right? So traditionally, we have also had a bias in favor of Singapore, at least for this part of the world. We, of course, being a global corporation, have footprint all across. So the choice may be different in LATAM, choice may be different in the US, but at least in this part of the world, it has historically been Singapore. But now, if a counterparty says, oh, I would want it to be Delhi seated, I would want I would retain the right to approach the Delhi High Court under the various provisions for. I would not shy away from that, right? But there could be courts in India, or there are a number of states which are not moving at the same pace as probably the Delhi High Court, which are not as familiar with arbitration as now Delhi High Court is, and I would not choose those states. So it's really the local court system, our comfort with that, and yes, the going in position historically has always been in this part of the world, Singapore, but that is changing because at least some courts are moving things at a pace and with the level of knowledge that we haven't seen earlier, at least here.
That's interesting, Kanishk. I'm curious to hear if you can share, like, what kind of counterparties are coming to you and asking for a Delhi court as opposed to an arbitration seated in Singapore?
So all domestic. So we of course we contract internationally, but there are a lot of contracts, whether they are investment contracts, whether they are just simple procurement contracts. They could be of different types. But if there's a domestic party, especially if it's an Indian party and not just a subsidiary of a global entity, then they do prefer India-seated arbitrations. There are 3 or 4 large cities which are generally seen in standard contracts that we get, but I would not choose a state or a high court which is not moving well, which is not reacting to arbitration in the same manner as some of the more developed jurisdictions might be. So I think it's still evolving, but just looking at everyone here, I'm sure a lot of us are practitioners. I think things are changing for the better in a lot of different pockets.
That's very refreshing to hear. So I think what I'm hearing is that for domestic contracts, you are seeing a trend now of having, let's say, Delhi-seated arbitration clauses.
Absolutely.
Right. And the other trend that each of you mentioned is use of SIAC and Singapore seat. And on that, I'll share, I've recently moved to Singapore. And one of the reasons behind that move is really this trend that you all are observing of Indian parties arbitrating in Singapore. In fact, SIAC came out with a report recently where it was noted that 66% of SIAC users are all Indian parties. And of that 66%, the SIAC has also studied that most of those contracts have been entered into the last 5 years. So even when we are advising our clients, where it's not a pure domestic Indian contract, where frankly we don't come into, where it's a cross-border contract with an Indian party on the one hand, or an Asian party for that matter, and a European or US party on the other hand, we are also seeing and giving that advice that you should really consider outside of India for the obvious reasons that we've discussed. And Singapore is being very popular, and SIAC is predictable, and so that has also been coming. ICC is another choice that we see. And Medha, to your point, LCIA also has a very good panel of arbitrators. Sticking with this point about arbitrators, I'm curious to hear from each of you, who are the kind of people that you appoint as arbitrators? So perhaps, Vikash, would you like to go first?
So the principal choice of arbitrators, whether it's from the panel of the institution concerned or the ad hoc, more hovers around the fact, I would say, is the understanding of the subject matter. That, at least historically in most of the cases, has been the fundamental driver. And the familiarity with the industry, the familiarity with the subject matter of the dispute, and understanding, which is the most important, I would say, understanding of the business context of it. Not only the pure law part of it. It's not about being the best jurist. It's about being the person with the best business understanding who can understand and decipher the real problem areas. And I assume Medha would throw more light on that. Than knowing the law as the best. So
I completely agree with you, and I think that goes for both arbitrators and the external counsel advising us. The commercial savviness of both the arbitrator as well as the counsel is extremely important, because at the end of the day, a lot of our disputes are about money. It's what is owed to us, which is why we have gone into this whole process. So in our case also, it's all about how money has transacted, where it has gone, how important it is to issue a certain kind of injunctive relief to be able to get it back, stop it from moving around within seconds from one wallet to the other. So so our choice of arbitrator is not just based on who's just a good lawyer who understands the law, but also who understands the business that we do, the business that the company is engaged in. And I would say that a lot of times institutional arbitrations obviously provide that comfort that they have on their panel arbitrators who have this kind of experience. For ad hoc, we need to do a lot of research. Not always believe what is written in the CV also. So there's a lot of industry knowledge that is exchanged amongst investors who are active in this space, and which is where we, in one of something that we actually ended up settling ultimately with the counterparty. But we did a lot of research in when we proposed the name of the arbitrator, whether he was actually the subject matter expert that he proclaimed to be or not.
And if I could just add a couple of points to that. So if we zoom out, one of the reasons why in the last many years, a lot of tech companies have gone in favor of arbitration as opposed to the court system is because a lot of us have felt that traditional judges or courts have not really appreciated or don't have the same appreciation for nuanced tech challenges, right? Whether it's a new technology being introduced, it's a new product being introduced. It could be across tech sectors, but all of us have felt that at some stage. And that's why we have gone for arbitration. And extending that logic when you're choosing arbitrators, or as Medha said, outside counsels, the same logic works, right? Someone who understands the industry, someone who understands the products, whether it's in the blockchain field that Medha looks at, or more traditional tech fields that we work in. Unfortunate reality is that a lot of traditional courts do not appreciate those, and that's why you're looking for that expertise. You're looking for that value add, which you'll only get in those experts. And so you're looking for not just expertise in the law, but something more than that.
just an example, in one of the recent arbitrations that we have initiated or has been initiated against us, it was purely on a subject matter, simple subject, not very fact heavy, around a very commercially dominated subject. And the choice of an arbitrator, the nominee arbitrator in our case, was, I'll give you the example, he was a ex-High Court judge, but on top of it, by qualification, he was a chartered accountant. So the very fact that he understood the commercial side of it was a big needle mover in his favor.
No, I think that's an excellent example. And a large part of what we do as arbitration counsel, as external counsel, is really research the tribunal members. And that means reading every decision that's public, written by that person. These days, media is so amazing that you can actually watch arguments done by that person, either in his or her capacity as counsel before. You read everything that they write. I have to say that, I'm a little bit nosy, so this is one of my favorite things to do when looking at an arbitration candidate. And the other thing which is not written, and this is something, that I'd encourage you all to call me, everyone in the audience, is there's a lot of know-how within the arbitration community, which is a very small community, and we'll share notes with you about our experiences with that arbitrator. And it really, that informal dialogue is very, very helpful. All that said, I will now come to my favorite topic. I'm your service provider. I'm external counsel. I want to peek into each of your brains and see, and you've given me a little bit of insight already, what do you look at when you're looking to hire somebody like me in a beauty contest? What's the motivating factor? So, Vikash, perhaps I can start with you.
Difficult question to answer on the face of it. But being honest to myself, as I said earlier, is the familiarity of the subject matter and the business that's on top of the list. The weightages of the criteria may differ from matter to matter, but understanding and familiarity is one factor. Cost, definitely. And here we are talking about the direct cost. The past delivery experience, whether directly or indirectly, what you mentioned, within the internal community when we exchange notes, the experiences of our counterparts or our colleagues in the industry as to how the delivery has happened and what was the experience and what was the depth of it plays a big role. And last but not the least, it's about, as I said, putting that business experience into practice. That ultimately is the real deal clincher, if I may call it. Someone who knows the subject but really can't put that into application, it's a zero result. But if someone understands that subject and can apply that in the real life scenario and get the results, that's valuable. There, the cost takes a little less dominance, and other things, the result becomes more important.
If I could, jump the queue and go next. See, for I'll slightly change the playing field here. Presuming that you are going to set of practitioners or the pool that you are looking at has the basic skills. So it's presumed that you have great experience in the field. It's presumed that you have the technical abilities and command over whether it's a subject or law, right? What is that differentiating factor that has moved the needle for us, right? It is that desperation that we would want to see that in our outside counsel that unfortunately we have, right? So as I said, it's not a happy experience for any business entity, notwithstanding the size. It's unfortunately the last resort, right? That you're in a dispute. In that scenario, very often we end up in a situation where you're just desperate, right? Sovereign could be on the other side. It could be a private entity. It could be anyone, but it's a desperate situation. So very often the first question I ask is, what do you know about us? What do you know about this dispute? How would you go about it, right? And if it's the very often that is the deciding factor, that what is the knowledge that you are coming in with? Are you prepared, or is it just another matter for you, right? I think that's what moves the needle for us, presuming all the basics are in place.
I agree with what both of them said, but I'd also like to add that I think we also select counsel based on a bit of word of mouth recommendations. Obviously, the industry is small enough that we know which lawyer in which jurisdiction is working a lot on these kind of matters. I think one of the factors that we've gone for when seeking advice and, in this sector is also to look at which counsels give you the most practical sort of advice. Like Kanishk said, disputes is really a last resort that we would go for. And I'm not really looking for a long drawn dispute resolution process also. Often, and we've discussed this, Sharmishta, before, that often settlements might be a better option for me. So I can tell you that we all also have a sort of within the industry little pool of knowledge about which counsel may just drag your case on, which is likely to give you a little more practical advice on what is the most cost efficient way of resolving this matter. I think that is also another angle that we give a lot of weightage to, that we really don't want to drag this on and on for just, just the sake of like winning, because it ultimately you don't know where the dispute is going to turn, which way it is going to go.
I'll probably convert what Medha said into a more direct answer. Naturally, the interests of an in-house counsel versus an external counsel are kind of not aligned. and I say that with a lot of humility, there is an inherent conflict. We want it to be over early as possible, and the fee of the council in most of the cases is linked to the tenure, the number of appearances, the number of hours. No offense to anyone. We all have been on either sides in most of the cases. But the councils which can cross this boundary and align their interests more with the client are the ones who are more successful in the long run and more likely to be selected than the ones who prefer short term gains, which is a one time assignment versus a one time fee.
Yeah, and
For being that.
no, and I couldn't agree with you more, Vikash. So what, and it might be music to some of the younger folks sitting in the room, that what I am witnessing and what we are seeing in the industry, and definitely what we are practicing is that we are not going for the biggest name. We are not going for someone who has the maximum appearances or maximum cases under the belt or is busiest. It is actually someone who comes in with that preparation, whose interests are aligned with us, who can put himself or herself in our shoes, and can look at an issue from our perspective. And it very often it may not be a long drawn arbitration or a litigation or any other dispute resolution process. It could be just that, oh, you should settle this. There is no point of dragging it out for that many number of years. So honestly, now it's really about whose interests are aligned, who can put themselves in our shoes and think like we think and how we would like someone to think on our behalf.
No, thank you both. And what I will say is my biggest victories are the ones you won't read about on my resume. They're the ones that are actually settled. They're the ones where the clients have been able to reach a commercial resolution. And really, our interests are aligned with yours. And sometimes when we get engaged, a part of that mandate is also to do a check-in with you at different stages during the arbitration when settlement offers may be appropriate. And sometimes an arbitration is just brought because that is the threat to bring the other side to the negotiating table. And that is never, the arbitration may never even go through the life of it. And that is really, again, the beauty of arbitration versus court litigation, because you can commence something and withdrawing it is not public. So it's not a public humiliation to your company, which may not be the same thing if you file in court. But all that said, all the things that each of you have said, I have been feverishly writing in notes in my head. But I want to explore this subject a little bit more about settlement. At what point in time do you consider settlement? Do you consider it after initiating an arbitration? Do you consider it at the outset? So perhaps, Vikash, since you've started this topic, let's start with you.
So again, there's no fixed rule to it. It differs from based on the context of the matter. Often I have seen, and this is a more journalistic answer, that when the tempers cool down, when we start the arbitration or a dispute, the tempers from both the sides or either sides are at its peak. I don't want to see your face types. And no offense to it. We as lawyers, whether in-house or external, try to stay away from those emotions, but there are emotions involved. Ultimately, there are human beings on either side. And what happens is, over the period, as the process progresses, those tempers cool down, or possibly the people on those assignments from either side move on, change. There are new people who start coming into that decision chair. And that's where I would say, when there are lower tempers, lower egos, and a more balanced approach, that a negotiation or a proposal for negotiation becomes, I would say, feasible. That feasibility can differ from matter to matter and context of it. At times I have seen settlement discussion come in after even 5 years, 7 years of the matter running, 10 years of the matter running. And in some occasions, just with the filing of the notice, something as simple as that. You file a notice and the third day the person is sitting in front of you, let's discuss. So it would largely vary with the context of it and how it happens, but we do have to keep the human angle, the psychological angle behind the decision makers into the context.
Important. Medha.
I find it interesting that you said that arbitration is often a negotiation technique because that is exactly one of our counsels advised us. Not getting a response from the other side, and it was like, let's send a notice, let's see what they come. It kind of, so I think settlement again is not something that would have a sort of a cookie cutter approach. You need to see on a case to case basis. In this particular instance, the initiation of that sort of notice was the way to get the party to the negotiating table, to reach a settlement. In other cases, I think we expect the counsel to sort of, again, take a very practical approach, align their interests with ours to see. Sometimes that settlement discussion cannot start up front. Like Vikash said, the tempers are frayed, you're irritated, you don't really want to see anyone's face there. So you need to find that right moment for it. And that is the sort of advice that we would expect from our external counsel, that this is the time when we can go for a settlement. Moving slightly away from arbitration, we've actually had a settlement that we had to do in US in a litigation that we were caught up in. And we really appreciated our counsel's advice. It was right at the point where he thought the court had given one preliminary order and he thought this is a good moment to actually go ahead and settle. And his advice pretty much was, I think it's right to settle this dispute today rather than you pay me all these dollars, just pay it to the other side, finish it off. Yeah. And that moment when the court rendered that preliminary order was the correct one to go for it because the other side was more amenable to negotiating. Mm-hmm. So I think it is, the timing of the settlement has to be a case-to-case basis, and the advice needs to be very practical based on what that case demands.
See, my response was going to be slightly different from both of my co-panelists. Settlement is always on the table. It's an option which is considered from the first day of any dispute till the last day, right? It's always there. We are not in the business or in the trade of disputes, right? Unlike some practitioners of law, this is not what we would want to devote our resources towards, right? So it's always an option that we are exploring. As Vikash and Medha said, it works sometimes. It's a great strategic option that one might choose. And others, you might want to initiate litigation or arbitration. You might want to explore how the other side is responding. So when you may choose is, of course, a strategic decision. But are you considering it? When do you consider it? I think every day. That's something that we very seriously look at all the time, every time, in every dispute, because we don't want to be in disputes in the long run.
Yeah, no, very valuable. I can see someone from the MCIA motioning to me that we are running out of time. So before I wrap up, I would like to invite perhaps 2 questions from the audience, if anyone. Please, sir. When you stand up, please state your name and just let us know who the question is directed to.
Thank you very much to the panel, Professor Kenneth Wayne, CIAB Kenya. 2 quick questions. First, does the geopolitical context impact all that you're discussing? So there's a lot of geopolitical issues happening, wars in Ukraine, sanctions and so forth. Does it affect questions around how Counsel looks at seats, how Counsel looks at the arbitrator, and so forth? Second, have you ever done interviews when it comes to choosing an arbitrator? I'd be very curious what your experience has been. It's a practice in some parts. I have sort of gone through something when it comes to selection, pitching, and there are all kinds of issues that pop up. Thank you.
Why don't you start with the response and then we can all chip in?
Okay. Well, starting with your first question, geopolitical considerations, yes. That is definitely influences, for example, where the seat of the arbitration will be. And I'll give you one real life example. We are currently in an arbitration against the Russian Federation. And needless to say, geopolitical considerations are top of mind there. If you are Russia, where would you like to seat the arbitration? The choices are few. And I will tell you, Delhi is a seat that Russia is considering very seriously. And why is that? Because India has not sanctioned Russia. Does our counterparty, the client that I represent, agree to India? We'll have to see about that. So that's the answer to your first question. But anyone else would like to chip in there?
Just taking the question a little more further and a slightly different context. Geopolitical considerations are there for everything, not only just arbitration, be it contracts, be it the contractual clauses, and how you negotiate, what are the securities, what's the performance bank guarantees. For example, without naming the country, we often have contracts with a particular country, which is kind of the biggest supplier in the space, in the renewable energy space. And if we have to get a security from that country or the counterparty, I would not agree to a bank from that country. I'm talking about a bank. I would not take a bank guarantee coming from a bank located in that country. Because I know if I have to go for an enforcement, I will never get that money. That is a piece of paper. So all those considerations beyond just the geopolitical, the very fact whether the institutions are impartial or not, they are independent, how far does that go, all those considerations play a big role.
And I think the short answer is that on most days we live in the real world, right? And we can't ignore what's happening around us. So whether it's entering into contracts, whether it's a dispute, whether it's selecting arbitrators or a seat, I think everything that happens around us needs to be considered. Only yesterday I was seeing an update about Nepal. Now that may not be our first choice for a seat or for looking for arbitrators, but everything that is happening around us does influence a decision. And if there are certain jurisdictions which are perpetually in turmoil, you would obviously not go around that.
I mean, 100%. I agree with what everyone here has said. I work for a South Korean fund. We have North Korea-related restrictions in all our contracts. We just don't bring them into the picture at all. You have to stay off. So geopolitical considerations would impact every part of your commercial dealings, not just where you're doing the arbitration or what institution you're selecting, but also just to begin with the contract itself.
And,
Sorry.
I see Neeti has a question.
Coming from an arbitral institution, I've always wondered this, that when there's an arbitration dispute and you're selecting your arbitrator, who has the final say? Is it your lawyers who are representing you, or is it the in-house lawyers who will say that, no, we want this arbitrator? Where does it really, I would say, the balance of the convenience lies, and who would really have the final say on the arbitrator?
And the client, that's always the answer. But that said, we try to guide our clients to make an informed choice. And like we were discussing earlier, we as arbitration practitioners may have inside knowledge about the arbitrator, which may not be in the public domain. So we counsel our clients. It's part of the services that we provide. But ultimately, really, it is the client that is deciding who to pick, and it's the client's choice because it's their dispute.
Totally. Ultimately, we get guided by our counsels, external counsels who do it day in, day out. Their experience of the arbitrator is much more deeper. We do arbitrations once in a while. For us, it's not our regular day-to-day business. For the external counsels who are advising us on that subject, for them, it's bread and butter. They deal with the arbitrator, or they, one way or the other, from either sides. So their dealings with that arbitrator, the chances of them having dealt with that person and having first-hand experience is much higher. So we do rely on the good advice coming from the counsels, but agreeing to it, that ultimate decision is being taken amongst the choices which are on the table by the in-house counsel.
I think that answers the question. So it's a bit of both. It's proposed by obviously the outside counsel. The options are put on the table, but then the final choice is of the client, as Sharmishta brightly put it. But you would be surprised by the level of knowledge that even the in-house counsels now have, right? Because in a lot of sectors, arbitrations are very common, right? And again, extended, why only arbitration? Whether it's arbitration, it's litigation. So that knowledge or institutional knowledge has now over time developed. And of course, the suggestions are very often coming from outside counsels. You're actually looking for a turnkey approach, right? Everything that once you go to an outside counsel, advice should not only be on the matter, but also on who you go to, how do you run the project, everything. But you would be surprised with the level of in-house knowledge that might exist, at least in some industries which get exposed to arbitrations very often.
Oh, with that I see, you guys cannot see the timer here, but I see 1 second and now it's marked 0, so, and a big red time's up, so that says time's up. All I can say is a very big thank you to each of the panelists. Thank you for coming. I know you have very busy schedules and traffic in Delhi is something to be afraid about, so thank you for coming. And thank you everyone for spending your Friday afternoon with us, and please do come outside and join us for some tea.
Thank you.